Good evening and welcome to the Federal. Earlier today, the names of Raghav Chadha and six other Aam Aadmi Party MPs were added to the list of the BJP's MPs in the Rajya Sabha. This is an updated list of the party's tally in Rajya Sabha. And subsequently, the Union Parliamentary Affairs Minister, Mr. Kiran Rijiju, also announced on X that the Rajya Sabha chairman, Mr. C.P. Radhakrishnan, has accepted the merger of seven AAP MPs with the BJP. The BJP's total tally in the Rajya Sabha has now gone up to 113 MPs. Now, this development of today, of course, comes just a few days after Mr. Chadha, along with six other MPs of the AAP, announced that they are merging with the BJP, and because they constitute 2/3 of the parliamentary bloc of the Aam Aadmi Party, they are exercising what Mr. Chadha called their constitutional right. Mr. Chadha has said that because they are 2/3 of the parliamentary strength of the AAP in the Rajya Sabha, they are entitled and allowed by the constitution, by the anti-defection law, to switch to the BJP without facing any action for disqualifying them. Subsequently, of course, the Aam Aadmi Party's leader in the Rajya Sabha, Party MP Sanjay Singh, had also filed a notice with the Rajya Sabha chairman asking for disqualification of these seven MPs, citing the same anti-defection law and saying that under the provisions of the anti-defection law, just 2/3 of the party MPs switching and announcing a merger with another party is unconstitutional because the original party has to agree to that merger. And in this case, that has not happened. And because Mr. Chadha and the six others have said that they are going to the BJP, they have voluntarily given up their membership of the Aam Aadmi Party and should be disqualified. Now, by all indications, of course, after their names being added to the BJP's tally, the Aam Aadmi Party is likely to challenge this decision in the Supreme Court. Party sources have said that they're already preparing a petition citing provisions of the anti-defection law. Now, we can't, of course, preempt what orders the court is going to give, but what we can certainly do is examine the anti-defection law, which has once again come into focus because of these developments. And I have with me today Mr. PDT Achary, former Secretary General of the Lok Sabha, to explain why this law was made, how it was amended to strengthen the mechanism for preventing defections. And now it's almost become a law that facilitates mass resignations, mass defections to the party in power. Mr. Achary, welcome and thank you for joining us. I'd like to.
Yes.
Yes, sir. I'd like to start with asking you, we have two sets of people here. One, the defecting lot of MPs who are basically citing the anti-defection law and saying that it is the law that allows them to move and merge with the BJP because they constitute 2/3 of the party's bloc. Their original party, the AAP, says that is not the case. They cite the same anti-defection law and say that what these seven MPs are doing is unconstitutional, and under the anti-defection law, they should be disqualified. In your view, sir, what is the correct interpretation here? Because there seem to be two sections or subsections of the anti-defection law which seem to clash with one another.
No, actually, there is no clash as such. If you carefully read the 10th schedule, which is generally known as anti-defection law, there is no confusion there. The paragraph 4, which allows merger as a ground for exempting members from disqualification, very clearly says that the merger has to take place between two political parties. Political parties, not the legislature party. Political parties. And in this case, the merger has to take place between the Aam Aadmi party led by Mr. Kejriwal and the Bharatiya Janata Party led by its president. These two parties have to merge with each other. And then members of parliament or members of the assembly, two-thirds of them have to agree to this merger. So only then they will be exempted from disqualification. Suppose less than two-thirds of the members of the House agree to the merger, the law will not allow that, and the law will disqualify them. So the point is, merger is between two political parties, and merger is not between the political party and the MPs, as it has happened in this case. And under this law, MPs have no right to merge with another party. MPs belonging to a party do not have the right to merge. They have the right only to agree to the merger. This difference we have to understand. And therefore, these MPs who have merged, they have used, I think, a wrong word. This merger can take place only between two political parties. And that must be clear.
Right. So just to recount, what you are saying is that when the anti-defection law says, puts across the two-thirds threshold, the two-thirds threshold does not act individually or independently from the original party. Both those conditions have to be met. It has to be a merger of the original party, and because of that, a merger of the two-thirds. It can't be either or. Is that what you're saying?
Not at all. Yes, that is what I say. So the merger has to take place between two political parties, and then the MPs, two-thirds of them, not less than two-thirds of them, should agree. So MPs can only agree. That is the thing. They cannot merge themselves. They have to agree to the merger and join the party. That's the thing. And if there are people, if there are MPs who do not agree with that, they can form a separate group and they will not be disqualified. That is also there. So the law is very clear that this benefit will go only in case there is a merger between two political parties, and the law insists that not less than two-thirds of the members should agree to this merger. That means if the MPs who agree to the merger are less than two-thirds, then also the MPs will be disqualified. That is what the law says.
Okay. So, but in this case, what these 7 MPs and what the BJP are also citing is the 2019 case where Mr. Venkaiah Naidu allowed again the merger of the Telugu Desam Party's MPs who had decided to switch again, of course, to the BJP at that point in time. Now, in that case, again, you did not have a merger of the TDP with the BJP, but then that merger of the MPs, because they were two-thirds, was allowed. So by going by what you're saying, was that again a wrong interpretation of the anti-defection law, and that merger it's also was done in an unconstitutional manner?
Well, I would say that if that has taken place, that is not in consonance with this law.
Right, sir. So there is also, this issue of how the anti-defection law is to operate when this two-thirds mandate, this threshold is met, when in what criteria it is not met, what causes disqualification. These are also issues that have repeatedly come up before the Supreme Court. There are, of course, Supreme Court judgments on it, seminal judgments, like in the case of, the split of the Shiv Sena, what is also popularly called the Subhash Desai judgment of 2022. What was the understanding, what was the interpretation given in those judgments on the operation of the anti-defection law with regards to, the scenario that we have ahead in front of us today?
See, in this Subhash Desai case, that is about the Shiv Sena.
Yeah.
Shiv Sena situation was different from the Raghav Chadha situation.
There it was a split in the party.
There was a split in the party, and both the factions approached the election commission. And under that simple order, election commission has the power to decide which faction is the real party, original party. And here in Maharashtra situation, it became a little tricky because the speaker did not decide the issue of disqualification of members who defected. Although petition for their disqualification was submitted to the speaker earlier in point of time. And only after that, there was a split, and then, a kind of a formal split, and they went to the election commission and all that. The point is that speaker should have decided that issue of disqualification earlier. And in that case, the situation would have been different. That is the thing. But that was not allowed to happen. The speaker was not, or perhaps, I don't know, the speaker did not take any decision on that issue. And in the meantime, these two factions went to the election commission. And one of the factions, that is the Shinde's faction, got recognition as the real Shiv Sena party. So that is a different situation. Here, there is no such situation. There is no split in that party. Only a few MPs of one house went over to the BJP and joined that party and called it a merger. And then they were accepted by the party. That is all what has happened. And the Aam Aadmi party, I understand, has given a petition to this chairman seeking to disqualify these MPs because, according to them, these people or these members have voluntarily given up the membership of the Aam Aadmi party. And that is one of the grounds on which a member can be disqualified.
Right. So as I said earlier, Mr. Sanjay Singh, who's the party, the Aam Aadmi party leader in the Rajya Sabha, had also filed yesterday a notice with the Rajya Sabha Secretariat addressed to the Rajya Sabha chairman, asking for these 7 MPs to be disqualified. Now, what the Aam Aadmi party is claiming is that while that notice was still pending, there has still not been any ruling by the chairman on, the demand made by Mr. Sanjay Singh, the party leader in Rajya Sabha. The tally of these 7 MPs has been added to the tally of the BJP, and the government, the Parliamentary Affairs Minister, has announced that the application moved or notice moved by Mr. Chadha and the 6 others for merger has been accepted by the chairman. Can the Rajya Sabha chairman act on one notice while his ruling is still awaited on another one, when the matter at stake is essentially the same, concerning the same lot of MPs?
First of all,
should there not have been a closure?
First of all, I don't think the chairman has accepted the merger as such, because chairman has no role in that. The merger cannot be or need not be accepted by the chairman. Merger takes place otherwise. It doesn't come to the notice of the chairman. It doesn't have to. Chairman has no role in that. Here, what happened, as far as I understand, it is under the rules framed under anti-defection law, that is 10th schedule, the leader of that party, legislature party in the house, has to notify the chairman any change that has taken place in the party, in terms of strength of the party. For example, if there is an accretion to the strength of the party, then it has to be notified to the chairman. And they will put it out in a bulletin. According to me, that is all what has happened there. There's no question of chairman accepting the merger as such. Chairman has no role in that. Law does not give any of this or assign any such role to the chairman. Because chairman, now that the petition has been filed by the Aam Aadmi Party, now chairman has to decide this issue in terms of the petition. And there is
the petition moved by Mr. Sanjay Singh. That's what you're saying.
Yes, it is a petition, not a notice. It's a petition. Yeah. Therefore, the chairman has to decide this issue in terms of the petition, as per the procedure laid down in the rule book. That is what is required to be done. Otherwise, therefore, I don't think that chairman has accepted. If anybody is giving that impression, that according to me is not wrong. Is wrong. It is not in accordance with the law.
Well, in this case, it is the Parliamentary Affairs Minister who's went out, who's gone out and posted this on his X handle, saying that the Rajya Sabha chairman has accepted the the request made by these 7 MPs. So,
well, I do not want to make any comment on what the Parliamentary Affairs Minister has said, but I was explaining the legal position. And then one more thing I would like to tell you. When the question of deciding which party a person belongs to, that has to be decided in terms of paragraph 2, an explanation. There is an explanation given in paragraph 2. And explanation A, to go through that, a member shall be deemed to belong to the party which put him up as a candidate in the election. So these people who have gone over to the other side, they shall be deemed to belong to the Aam Aadmi Party only till the decision is taken on this petition. That is what that particular explanation means.
So, by extension, when they say that they have decided to merge with the BJP, does that then align with what the Aam Aadmi Party is saying, that they have voluntarily given up their membership? Can that be interpreted in this sense, that they are voluntarily giving up their membership?
Well, that is their plea. And now, of course, the chairman will have to examine that plea in terms of evidence and all that, and then take a decision. Now that the petition has been filed before the Honorable Chairman, then it is not proper for us to comment on that. So the Honorable Chairman will have to take a decision on that.
So one legal point here then, that as you say, and from what we've been given to understand by the Aam Aadmi Party, there has been no ruling by the chairman on the petition that has been filed by Mr. Sanjay Singh. Now, does that prevent the Aam Aadmi Party from moving court because the ruling hasn't come? And since, the ruling again, there's no time-bound manner from what I understand within which the chairman has to give his ruling. It has to be a reasonable time. But the reasonable time we've seen in previous cases is at times most unreasonable. So does the Aam Aadmi Party have the right to move the Supreme Court at this point in time, or will it have to wait for a ruling from the chairman?
See, you can't expect the chairman to give a ruling within a day. As I understand, the petition was filed only yesterday, and the chairman has to give sufficient time, reasonable time to the members who left this party to explain their position and to put up their defense, prepare their defense, and then they will be given a hearing. All that, it will take some time. So you cannot expect a ruling from the chairman. Ruling means final ruling. Right. That is the decision of the chairman after hearing both the parties, and that is the proper way. Of course, earlier the law does not prescribe any particular timeline within which to decide this issue. But Supreme Court has in one or two cases said that within 3 months in normal case or in normal course, within 3 months, the presiding officer should be able to take a decision on this. So that is before us. Therefore, the chairman or the speaker will have to adhere to that timeline prescribed by the Supreme Court.
And so, in the pendency of that decision, can the AAP still go and file a petition in the Supreme Court, or it will have to wait for the ruling to come?
No, they cannot go to the Supreme Court at this stage.
They cannot go at this stage.
Because the decision has to be taken by the chairman. He acts as a tribunal. And so at the first stage, the decision is by the chairman only and nobody else. The court will not come into the picture. It is the chairman who has to take a decision. And only after that, you can challenge it in the Supreme Court.
So let me look at a more broader question of the anti-defection law itself. Over the last several years, and particularly the last decade, we've seen the opposition raise these demands for a reform in the anti-defection law, for making it more stringent, because we've seen, this en masse defection, party hopping, happen very frequently in state assemblies. Now, of course, we're seeing that also happening in parliament. And this demand has been made repeatedly for making the anti-defection law more stringent. In fact, ironically, Mr. Raghav Chadha, the first private member's bill that he had moved in the Rajya Sabha after becoming a member of the Rajya Sabha was for making the anti-defection law more stringent. And if Mr. Chadha's private member's bill had been accepted and passed, it would have made it impossible for him to have defected to the BJP today. In your understanding of the anti-defection law, as it stands today, and in the current environment, political environment, plus your experience of being a Secretary General of the Lok Sabha in the past, do you think that the anti-defection law today needs to be strengthened, or are its remedies, or what its mandate is at this time, if it is followed to the T, it is sufficient, or does it require an updated, upgraded, reformed version?
Well, as per my understanding of the law is stringent enough, because after the 2003 amendment made to this law, the law has become more stringent, because there was a provision for split, and that was misused by members.
In the original law, that you mean?
Yeah, and then the Parliament amended the law and deleted that provision. There's a provision for split. 1/3 of the members moving out, and then they become a group, and they will not be disqualified. That was the provision at that time under paragraph 3. So that paragraph 3 was omitted because a lot of defections used to take place making use of that provision. Now, what remains is only paragraph 4. And that, I think, in itself is very stringent, because that has made it almost impossible for any defection to take place. As I explained earlier, now the members will be exempted from disqualification only if there is a merger between two parties. And that normally doesn't happen. Merger between two political parties. That is the thing. So we must know that the law has made it almost impossible for members of parliament or members of the assembly or state legislature to do this party hopping. It's not possible. But then it depends. Actually, what is required is a firm ruling by the Supreme Court on this issue. This 2/3 of the members, that creates created a little confusion. Some maybe because of some ruling given by a single member bench of the Bombay High Court in some case, but that was absolutely wrong decision. If you go through the wording of paragraph 4, it becomes very clear. It becomes very clear. That means the members of parliament, 2/3 of the members can only agree. They cannot merge themselves. They have to agree to a merger which has already taken place between two parties. And things are very clear. So what I'm saying is that the law as such contains very stringent provision today. After the split provision was removed, the law is very stringent enough to prevent this kind of defection. And if still members are doing it, naturally, the court must step in, and the chairman and the presiding officers of the houses, they must also take a very strict view of things. That is it. They must also go by the provision, the wording of the provision, the text of the provision, and decide things accordingly.
Right. So it's as much the responsibility of the presiding officers of both houses of parliament, or the speakers of assemblies, to ensure that the spirit of the anti-defection law endures and it doesn't end up being a law that is misused frequently, as we've been seeing over the years, and in the latest case of DR. And if the presiding officers don't step in, then at least one hopes that the Supreme Court would step in and give that clarity, that the spirit of the law should endure.
Certainly.
It perhaps does not require a reform, but clarity on what the law really mandates.
Absolutely. That is what is required. That is what is required. The law is strict. The parliament has actually made this law strict. They have tightened the whole thing. And the presiding officers should keep in mind the object of this law, that is to prevent defection and not to encourage or facilitate it. That is the thing. If people are looking for loopholes in the law, it is the duty of the presiding officers or the houses to not allow them to exploit such loopholes. That is the thing.
Right. Thank you, Mr. Achary. Thank you very much for your time and for explaining this rather complicated issue in a way. Thanks. Thank
you. Thank you.